I know you sent me the link yesterday, which I thank you very much, to say that landlords can start repossessing again. We thought 23rd of August, but it's been extended now to September for 4 weeks.
Yeah. Yeah.
So what does that mean for a landlord with a tenant
Well,
arrears?
I do remember most of us, obviously, over the corona period, the Coronavirus Act effectively was rushed into an act of parliament. And there were various amendments, changes that was effectively took effect from the beginning of middle of March. One of the most proponent effects on the landlords, buy-to-let landlords, was the suspension of the right to evict a tenant. And it applied across the board on commercial as well as residential. And the effect of the suspension was anybody who had either submitted a claim or served notice to a tenant on a residential property or a commercial property, they were not allowed to proceed with taking it further through to court during the period of the coronavirus. We were told at the start that that suspension would only be for about 3 months, and then it would be reviewed. And then obviously we were told that extension happened till the end of August. And then we're now told that it's been extended a third time to the end of September. The consequences are quite draconian, quite dramatic from buy-to-let landlords' point of view, because I do a lot of litigation, although I have to stress point. I want to tell people about my club at the end, if you allow me.
Yeah, of course.
The Property Pillars Club. I'll talk about that later.
Yeah.
But basically, for most of my clients, the biggest impact is on the non-payment of rent arrears scenario that a lot of my buy-to-let landlords have now become victim of. I had a number of cases going through court anyway for my clients. The situation is really quite a sorrowful one for the buy-to-let landlords, because they're faced with having to deal with non-payment of rent from tenants who, because of the Coronavirus Act, you cannot take to court. And as you know, without a court order, you cannot remove a tenant lawfully from your property. So the buy-to-let landlords are the unfortunate people who are having to pick up the bill of this rather expensive, draconian piece of legislation which suspends any form of litigation action against the tenant.
So
now what they've done, what they've done is they're proposing to also extend the notice provision to 6 months, because prior to coronavirus you had the Form 6A notice provision that was 2 months of duration, and you had the Form 3, which was 2 weeks duration. But they suspended that provision and said that you now need to give 6 months minimum notice to the tenants. So apart from the fact that you can't issue proceedings, or proceedings are suspended, at least up until the end of September, you also have to start putting in longer notices to those tenants during this period.
So what happens if somebody's actually in quite a bit of arrears? Do you actually put in to the court after September and then have to give them 6 months notice?
Well, no, you can put in the notice now and give them 6 months notice now, and when that notice expires, then you have to issue proceedings at that stage.
So even if they're in arrears now?
Yes.
You can only issue now, and that it's going to take 6 months to evict anyone from now?
Correct. So you can put in notice now.
Yeah.
The notice has to be for a duration of 6 months.
Okay.
And after the notice has expired, then you can issue proceedings at the county court.
Right, and what happens
now,
in
so there's some people who have issued proceedings prior to March, when the Coronavirus Act came in, and their hearings were pending in court.
Yeah.
And in those people who are sort of in the middle, they have to serve what they call a reactivation notice to the courts and to the tenants to tell them that they intend to reactivate the case. Now, if they don't serve a reactivation notice to the tenant and to the court, their case is automatically suspended.